It's great to be back with all of you on November 29th. Who would have thought that we'd be nearing December, hoping that all of you had a terrific Thanksgiving and that you put aside your pregame activities ahead of the World Cup match at 2 o'clock to join us today. It's a full agenda. We've got a lot to cover, and we're glad that you've taken the time to be with us. So Kathy, if you would please go to the next slide, I'll walk the group through what we have ahead. So I'm going to be spending some time after I walk through this agenda, going through the activities of Governor Hochul relating to legislation. In particular, there have been a number of bill signings and a number of vetoes, and we just want to keep you up to date on what's happening there. Then Steph Fedorka, who has been on this program a number of times, has come back, and she'll be describing amendments to Labor Law 215, specifically relating to prohibitions of retaliation for lawful absences. This is also part of some of the recent bill signing activities, so it will bridge off of what I'll cover. Then Tim McMahon, who is a senior counsel with our firm out of Syracuse and on the program for the first time, will be sharing his background as a litigator and discussing summary judgment. There's some interesting aspects to essentially rules that were in place and then weren't, that he just wants to make sure all of you have an awareness about. Then we'll be hearing from Delaney Knapp and Shannon Knapp. Delaney is based in Albany, Shannon in Syracuse, and they'll be talking about, apropos to Giving Tuesday, which is of course today, about tax, fundraising, and privacy laws in the context of launching your nonprofit website. I'll come back. I'm going to cover the healthcare worker bonus, just to let you know what's new there. I'll touch on what we know about COVID since last I gave you a briefing on that. And then if there's time, we'll make sure to cover anything you raise forward to all of us. But for now, why don't I move into the next component of our presentation? And as I mentioned, bill signings are definitely picking up. And one that just happened this week, you see depicted here through the press release of the governor's office. There's legislation that the governor chose to sign concerning protecting patients with medical debt. This is the time where, up until the close of the year, the governor has the opportunity to sign those bills that are approved by the Assembly and the Senate and then ultimately delivered for her signature, which is a critical technical step. And there's zealous advocacy underway to make sure that the bills get to the governor and that she signs them within the prescribed period. And so, as I mentioned, there's this ban on garnishment activities and property liens in connection with healthcare debt. That's what you see depicted over there. There's a not-for-profit piece that's important, at some level connected to what Shannon and Delaney will cover, essentially working through to streamline various reporting and transparency requirements. This also came through legislation that the governor signed that's intended to help nonprofits. And then there is another bill that recently was signed that offers clarifications to what informed consent is and essentially add some color around patients' rights. Why don't we move to the next slide, please, because there's a context to all of this. The governor is also vetoing bills and doing so at a pace that is absolutely distinct from where things were just before the election. I think now that the election is behind us and there's some clarity concerning essentially her continuing leadership role, the governor has decided to offer her voice by indicating in a variety of different settings that legislation did not strike her as appropriate to sign into law. There have been a number of bodies, commissions and the like that in particular have been cast aside by the governor. And we expect to see more bill signings and potentially vetoes in these coming weeks as we move into December. But let me give you a flavor of just some of the types of vetoes that we've seen. This is up to date, and I think our library team for pulling this for me just before we came on here. One of the most recent vetoes concerned a special joint legislative commission on affordable housing. There was another one concerning the establishment of the New York Asian American and Pacific Islander Commission. Yet another concerning a requirement that would have been imposed on the Office for People with Developmental Disabilities to produce and publish a report on staffing at state-operated institutions. And the list goes on. There's one concerning a study around immigrant and refugee participation in adult education and the workforce, and LGBTQ plus advisory board. There's a theme here. These are boards and commissions, and the governor has said that these are the types of activities that she sees as more appropriately essentially proffered through the budget process because there are funds attached to implementing them. And so this is a bit of a distinction that we're seeing surface as we move into November, December. There are many more bills out there that have nothing to do with commissions or similar type bodies. And so we'll be tracking those as we move into the next month. And we're excited that we'll have the opportunity to continue to keep all of you up to date. There are issues that in our broad audience we know affect some of you more than others. And so we want to make sure that we're giving you the best snapshot of what's happening as the governor applies her pen or chooses not to, as it were. And so with that, why don't we move to the next slide, please? And it's a good time to introduce Steph Fedorka, or reintroduce Steph to all of you. Steph is based with a foot in our Syracuse and a foot in Rochester offices, and has presented before you many times on labor and employment matters, and has taken a close look at the amendments signed into law around 215 and those prohibitions on retaliation. So Steph, I'd love for you to walk the group through why this is important, please. And thank you for coming back onto the program.
Absolutely. Thank you so much, Gabe. And thank you all for joining us this lovely afternoon. I hope you all had a restful holiday. Next slide, please, Kathy. Thank you. So right before the holiday, on Monday, Governor Hochul signed amendment to New York Labor Law Section 215. The law will become effective 90 days from her signature, her enactment. So putting that effective date February 19th, 2023. A little bit of background on what New York Labor Law Section 215 is to begin with. It's the anti-retaliation provisions within the New York Labor Law. And those have existed for some time now, and essentially makes it unlawful for employers to retaliate against employees by means of discharge, penalizing them, or in any other way discriminating or retaliating against them for engaging in what we call protected activity. Protected activities under New York Labor Law Section 215 can include things like making complaints about labor law violations to the Department of Labor or someone else, providing information to the Department of Labor, testifying in an investigation or other proceeding under the New York Labor Law, or exercising rights protected under the New York Labor Law, or causing an employer to receive an adverse determination from the New York State Department of Labor. Next slide, please, Kathy. So what's new, and this should really be in quotations, because what this law does is it really clarifies and codifies what we already generally know. And what is that? Is that employees can't be discharged, threatened, penalized, or in any other way discriminated or retaliated against for using any legally protected absence pursuant to federal, local, or state law. And I say this isn't really new, and it really is intended to clarify these already existing protections, because most, if not all, of those lawful absences or leave laws that apply to employees will have retaliation provisions already within those laws themselves. But that said, the law goes a little bit further here in these amendments to New York Labor Law 215 and clarifies that assessing any demerit, occurrence, any other point or deductions from an allotted bank of time, which subjects or could subject an employee to disciplinary action, which may include but not be limited to a failure to receive a promotion or loss of pay, would constitute such unlawful retaliation, discrimination, or penalty under New York Labor Law Section 215. Next slide, please, Kathy. So what does this mean, or what's this potential impact for employers? So what this law does, or what these amendments do, is that it calls directly into question any no-fault or points-based attendance policies, particularly those that take any absence into account, right? As opposed to those that might not count lawful absences into those attendance-based points-based attendance policies, rather. There's a potential impact, I think, as well on attendance-based bonuses based on that loss of pay language that we see in those amendments as well. But I think we might have to unpack that a little further, or I would employ you to reach out to your favorite labor and employment attorney if you have attendance-based bonuses to unpack and figure out and analyze whether or not there are risks associated with that attendance-based bonus. Next slide, please, Kathy. Importantly, I think a reminder, penalties for violations of New York Labor Law Section 215. A first offense can carry a penalty from $1,000 to $10,000. A second offense can include a penalty of $1,000 to $20,000. And those are assessments that can be made by the New York State Commissioner of Labor. So an employee could go to file a complaint with the Department of Labor, the State Department of Labor, and they would investigate and could assess penalties if the violation is found to have merit. Back pay, if an employee was owed back pay, liquidated damages, potential reinstatement, front pay in lieu of reinstatement, if an employee was terminated improperly or unlawfully, any other appropriate relief that might be available. It also has a private right of action, so employees could file a lawsuit. There's a 2-year statute of limitations associated with that private right of action, and a court could assess or award attorney's fees and reasonable costs. I think it's also relevant to note that a violation of New York Labor Law Section 215 is also technically would constitute a violation, or an individual would be guilty of a Class B misdemeanor. So I think it's important to understand what penalties are involved for violations of New York Labor Law Section 215, particularly in light of these additional amendments. Next slide, please. So what should employers do at this point in time in light of these changes and preparing for that effective date of February 2023, February 19th? You should review your attendance policies or leave policies. Make sure you revise anything accordingly, particularly if you do have a points-based attendance policy. You should educate decision makers, maybe do some refresh training. I think it's always a good idea to educate your decision makers, your supervisors, kind of your frontline decision makers there regarding unlawful retaliation, particularly with respect to attendance issues or attendance problems and protected or lawful absences. Consult legal or your favorite labor and employment law attorney regarding any policies that might be implicated by these amendments. If you do have an attendance or points-based attendance policy, or if you're just not sure whether or not your attendance-based policy or your attendance policy is compliant, or if you have any concerns about being compliant with these new changes, as well as, before you take action against employees based on any attendance, particularly when that employee has taken a legally entitled leave of absence or used one of those lawful absences under federal, state, or local law. Stay tuned for any further guidance from New York State Department of Labor on the amendments, but don't hold your breath. And certainly reach out if you have any questions. And again, I implore you to prepare and review your policies and get ready to comply with the law moving forward.
Steph, thank you so much for that helpful update. And I encourage all of you to follow Steph's guidance and prepare, and to please reach out to the bond attorney with whom you work most closely if you need our help in doing that. And so let me then invite our next speaker, who is Tim McMahon. Tim represents clients in various litigation matters, including declaratory judgment actions and insurance coverage disputes, among other matters. Before joining Bond, as I mentioned, he's based in our Syracuse office. He was also a principal law clerk to Judge Joseph Lemondola at the Onondaga County Supreme Court, and also within the Appellate Division 4th Department, served there. And so he comes with a very significant background in the litigation processes generally, and wants to update us on what is essentially a quirky type of issue where there were standards in place for the better part of 18 months, but now they have been unwound, and there's some interesting ramifications around all of that. But Tim, I look forward to you bringing us up to speed on what it is we're talking about here. Welcome to the program, and looking forward to learning along with our audience. Thank you. Tim, we're not hearing you, so if you wouldn't mind, there we go.
I was just going to say I'm brand new to the program and already off to a great start with not getting my Zoom controls correct. So Gabe, thank you again for the opportunity to come here and speak to everybody. The topic today I'm speaking on is a little quirky. It's a summary judgment rule. And for those of you who don't know, summary judgment is a procedural tool that is typically used at the beginning of litigation to try to narrow the issues for the case, to try to dismiss a cause of action early. And interestingly, in February of 2021, a rule was created in which a moving party, the party moving for summary judgment, would be required to submit a separate, short, and concise statement in which they believed would be undisputed material facts in support of their motion for summary judgment. In opposition to that, the opposing party would have to oppose it. They'd have to oppose it by confronting it with evidence or an affidavit or some other material in the record. And as you can imagine, this came about kind of in the midst of COVID. The rule wasn't circulated entirely. It wasn't described perfectly, and it was different. And it was different because the commercial division rules didn't require it. It had never been required in the past. So when it's administered, the plain language of the rule didn't provide any discretion to the trial courts on how to deal with it. The provision itself used the phrase shall, that it was required to be submitted as part of the moving papers, and it was required to be opposed by the opposition papers. And of course, as you can imagine, this led to some very harsh consequences. The trial courts did not necessarily know how to deal with it. So in many instances, when a moving party, that being the party who brings the motion, attaches this statement of material facts to it, articulating the facts in the case that it didn't believe were disputed, if those weren't opposed, based on the plain language of the rule, the courts felt like they had to deem those facts admitted. And there was a handful of cases that came out in this time period, in mid to late 2021, in which summary judgment motions were granted solely on the failure to oppose a statement of material facts. And this is unique because again, the commercial division rules did not require this. The civil practice law and rules didn't require this. And again, it was unraveled kind of during a time when some people were still working from home. The courts were not fully operational yet. So finally, on July 1st, 2022, just this past summer, this particular rule, and this rule is found in the Uniform Rules of Trial Courts 202.8G, it was amended to effectively eliminate this fatal consequence. This consequence that if you fail to oppose the statement of material facts, that they won't all be deemed automatically admitted. It gave the discretion back to the trial court. So it harmonized the rule back to the commercial division rule, in which the trial court can take a look at what's been submitted. It can deem them admitted. It could give the opposing party an opportunity to confront them, even if it initially failed to do so. It essentially gave the trial court all the discretion that the initial rule, the original rule, completely left out. So the question with all this is why does this matter? Why does this rule that is no longer in effect, it was only in effect for 18 months, why would it matter to anybody who who was involved in a case that this rule applied to at the time? Well, like I mentioned earlier, a number of cases were actually summary judgment was granted because the rule was not complied with. So the natural question is what happens to those cases when they go up on appeal? What is the appellate division going to do with those cases? Are they going to apply the rule as it was written back between, say, February of 2021 and July of 2022? Or are they going to interpret the rule as it's written today? Interestingly, the third department confronted this issue in Lieberman case. And for those of you who want the site, it's 207 AD 3rd 850. It was decided just in July. And what they did is they compared the old rule to the rule that it was supposed to model. And that's the commercial division rule that had been around for many years prior. And that rule provided the discretion to the trial courts to assess the remedy for failure to comply. And they held, that third department case held that despite the mandatory language included in the original version, the trial court still had the discretion to deem the facts admitted. And even more recently, the fourth department in a case that was just decided about 2 weeks ago, Smith versus MDA Consulting, and this just only has a Westlaw site at this point, 2022 Westlaw 168-47850, they applied the same standard, saying this rule, while modeled after the commercial division rule, should be interpreted the same way and should leave the discretion to the trial court to interpret whether or not a failure to comply with this rule results in the automatic admission of certain statements of material fact. So what should you consider if, say, for example, you made a motion for summary judgment, and in your motion for summary judgment, you laid out all the statements of material facts, and your opponent failed to oppose those, and your motion was granted on those grounds? Well, if that is up on appeal, it is highly unlikely that you're going to be successful on that motion for summary judgment, or at least getting affirmed on that grounds. But keep in mind that just because your motion was granted on one ground, if you raised other theories before the trial court, which I assume you did, you can raise those, of course, before the appellate division and seek what the appellate division will accept as alternative grounds for affirmance. Okay, so there's other ways for the appellate divisions to entertain your merit-based arguments. And those two cases that I cited earlier, they did just that. They put aside the threshold issue of compliance with the uniform rules, and they decided the case on the merits. Now, it wasn't necessarily successful in both cases for the party that won before the trial court, but they were still able to raise other merit-based arguments to potentially get the same ultimate result. Other considerations. Be mindful that the trial courts are still adjusting. Okay, they adjusted to the new rule. Now they're trying to adjust in the same way with the most recent version. And in doing so, while they have discretion to interpret the rule a little more broader than the old rule, they also have the discretion to require material statements of fact. Okay, and when they require material statements of fact, you must provide them. Of course, again, they have the discretion to deny the motion without prejudice and follow up with you to get those statements of material facts. But I think it's a good practice to do two things. And it's interesting, we have a lot of rules now surrounding summary judgment. We have the civil practice law and rules. We have the uniform rules if you're in the trial part of Supreme Court, and we have the commercial division rules if you're in the commercial division. So we have a lot of rules to look at before we make a motion for summary judgment. And I think we also have to always be looking at the court's individual rules, okay, because those rules will tell us whether or not that particular trial court is going to require a statement of material facts. The other thing I would consider doing is making reference to the old rule. If you make a motion for summary judgment and say, for example, your trial court does not require statement of material facts, I would put a footnote somewhere in your moving affirmation or your memorandum of law, just outlining for the court that the rule has now changed and the statement of material facts is no longer required. And interestingly enough, When I did this, a memo that I believe is going to be provided for everybody back in October, I made a motion within a couple weeks after, and I didn't follow my own advice. I didn't put that footnote in. I didn't make reference to the old rule. My opponent was a experienced litigator, and sure enough, when he opposed my motion, he brought up the argument that I didn't comply with the uniform rules. He was citing to the old rule and arguing that my papers were defective because I failed to attach a statement of material facts. Well, I put myself in that position where then I had to raise it and reply. I know that I'm correct on the rule change and when it was changed, and I attached all that for the court. I certainly could have eliminated all of that if I had made reference to it. So it's a very narrow issue. It's an issue that many of you possibly were not affected by. It only comes up in the summary judgment context. But again, some of you may have been successful in winning summary judgment during this time period. And if that case is up on appeal, it could change the lens and how you are going to draft your papers on appeal. So keep that in mind if that has affected you in a meaningful way. If not, just take note that the rule has changed. It's relaxed, but take a look at it and be mindful that the individual judge can still require it. And if the individual judge still requires it, be careful with your compliance, because again, through the eyes of certain judges, it can have some very significant consequences. Again, Gabe and everybody, thank you for the opportunity today. It's been a pleasure.
Tim, we're so glad you made the time to educate the group and to bring everyone up to speed on the issues in summary judgment that certainly were not as familiar to me before you presented on them. So thank you for taking that time. And for anyone who's looking, for the piece that Tim wrote covering some of these same issues, I understand that you should be able to find the link for it within the chat function. If for any reason you can't find it, you can reach out to any of us, particularly to me or to Tim, and we'll make sure that you do have it in hand. And with that, Tim, please know that you're welcome back on the program whenever you have information to share with this group. And I'll move on to the next in our lineup. So Tim, again, thank you. And as I mentioned at the top of the program, we're joined this afternoon by Delaney Knapp and Shannon Knapp, who are not only two attorneys who share the same last name, but also who have a subject that they both feel passionately about in terms of both their knowledge and their background. It's about helping organizations who are in the nonprofit space think about what a website needs to look like. There are lots of dimensions that one wouldn't necessarily think about unless walking through in the formal way that we're about to hear about by way of the presentation that they'll be delivering. And as a reminder to all of you, Delaney is based in Albany. Shannon is based in Syracuse. Delaney focuses on not-for-profit issues. Generally, Shannon brings expertise in privacy and cyber. And so we're really glad to have both of your minds applied to these issues, particularly on Giving Tuesday when so much of it is apropos. So please go right ahead. Looking forward to learning more. Thank you.
Thank you, Gabe, and happy Giving Tuesday. I encourage all of you today to think about the organizations, the nonprofits that have impacted your lives, maybe your families, that have missions you support, and think about donating to them. In line with that, Kathy, if you could go to the next slide. I'm going to cover the first half of our presentation and talk about some of the nonprofit considerations for your websites, and Shannon will cover the latter half with respect to data privacy and security. So when you form a new organization, or maybe when you're revamping your website, this is a really exciting time for nonprofits. You're putting your organization out there for the world, for everyone to see. And a lot of questions come up with respect to what should be posted or uploaded, what information should be available to people who visit your website, donors, stakeholders, things like that. So we've put together a list of, I believe, 10 of our top questions that we get to just go over what you should be thinking about when creating your websites. Next slide, Kathy. So a lot of the questions relate to what types of documents can be posted online. With respect to your bylaws, they don't have to be posted on your website, at least in New York. And I'll just use that. The frame of reference for our conversation today is from a New York law perspective. Other states may have different requirements. So you would want to check, with counsel for those. Like I said, many organizations do, though, choose to upload their bylaws or other key documents like their certificate of incorporation, maybe their conflict of interest or whistleblower policies. There's really no new risk or confidentiality concerns with posting these documents, just because they're generally widely available anyways. When you file with the New York State Office of the Attorney General Charities Bureau, some of these documents will be uploaded. Having them publicly available demonstrates your commitment to transparency and can help instill confidence in your organization's governance and leadership. Next slide. Okay, so what about your Form 990 tax returns, your annual information returns? Is it safe to publish them? So safe, yes, in the sense that it's not creating any new risk. They are publicly available, as we've discussed other times on the webinar. There's many different websites that post these information returns that donors and other individuals can access to review your organization's finances. So they're going to be on the IRS website, on the Charities Bureau website, on third-party platforms like GuideStar or Charity Navigator. So you may as well post them yourselves. This can provide donors and stakeholders with information that may inform their giving decisions, as we've talked about previously, such as giving in times of crisis, or generate interest in collaborative partnerships or projects with your organization. Next slide. So then, do you need to register your organization anywhere before you start raising funds? Most nonprofit websites nowadays offer options for making donations online using like a donate now button or linking to third-party fundraising platforms. Charitable solicitation laws are state laws, not federal. And so, like I mentioned previously, each state has its own specific requirements for when registration is required. With respect to New York, you can register and should register prior to soliciting funds within the state. That is the policy of most states that we have reviewed or worked with previously. And if your nonprofit is soliciting contributions online, rather just in person or by mail, you should start tracking receipt of your donations by state and working with your counsel. We would be happy to help to determine when donations from a given state are approaching a threshold that may require registration. So some states say, if you're bringing in more than $25,000, more than $50,000 from residents of that state, you need to register there. Next slide. And what about information about your tax exempt status? So this specifically references 501c3s because those donations are tax deductible. There's no required language, nothing you are supposed to have. There's no template, but using correct terminology and making this available and easily accessible for donors will provide them clarity and avoid creating any inaccurate expectations with respect to the gifts that they make to you. So here we have a sample language. This is also included in the article that we published on this topic as well. And I just wanted to note that having this language on your website is not a substitute for any donor acknowledgement letters that you're required to send out under federal tax laws. So post this language, let donors know that you're a 501c3, but also make sure you're complying with those gift acknowledgements as well. Next slide. So some people, you submit your 501c3 letter, but the IRS takes about 6 to 8 months these days to process them. So what are you supposed to be doing in the meantime? We commonly recommend refraining from soliciting while your exemption is pending. Now, typically, you submit your application, and as long as you do it within the 27 months from formation, your exemption will be retroactive back to the date that your entity was incorporated and legally formed. However, sometimes things can go wrong. If you're not working with counsel, you're submitting it yourself, there's a chance you could miss that post-formation filing deadline. Maybe retroactive exemption isn't granted. Maybe the IRS takes the position that your organization's purposes are not actually exempt under 501c3. In any of these circumstances, if something goes sideways, your donors who made donations during that interim period where you weren't confirmed exempt, their donations would not be tax deductible. So that's where the risk is of soliciting prior to having that 501c3 status. In New York, your Charities Bureau registration can now be completed prior to receiving that exemption. You would just go back online after you get your determination letter and re-upload it. But this may not be the case in all states that you're soliciting from. So you would want to double check or ask your counsel to do so. Next slide. And we know people really want to give you money up front. You want to get going, you want to get started, but nonetheless, we recommend exploring other options in situations like these when feasible. It can be hard to wait that 6 to 8 months before getting started, but another option would be working with a fiscal sponsor. So this is another 501c3 exempt entity who can receive and administer charitable contributions on your behalf until you're legally able to do so on your own. Next slide. And I think this is my last one. With respect to information that you can supply regarding your board leadership, just make sure you're following ordinary safe practices when you're posting your board's personal information. Typically, you'll see names, titles, sometimes contact information like an email address that's linked to the organization, maybe not personal email addresses or personal phone numbers. You can also upload photographs of directors, of your officers, and your executive staff. This can help to personalize your mission and the activities of your organization. You can use it to highlight the experience of your leadership, especially if they're well known in your community or in the nonprofit sector, and can instill a sense of accessibility to those individuals who are managing and operating your organization. And I think that's my last one. Kathy, if you can go to the next slide, and we'll hand it over to Shannon.
Thanks, Delaney. So I'm going to talk a little bit more about the cyber and privacy side of websites, particularly for nonprofits. So the first question is, what is a privacy policy, and do you need one on your website? So a privacy policy is a document that describes basically an organization's general practices concerning personal information and how it obtains it in the course of its operations. And it usually includes a lot of different information, such as what information you're receiving, what you're doing with that information, if you're further disclosing it outside of your organization, marketing, donations, all that type of information. And this policy really helps website visitors understand what's happening to their personal information so that they have choices and understanding around what's occurring. And this has become increasingly important recently as a lot of different enforcement agencies are finding that it's a best practice to have privacy policies on your website. And it also helps with what Delaney mentioned earlier in terms of transparency, meeting consumer expectations, and building trust and transparency with your stakeholders, donors, and other visitors to your website. And privacy policies have become increasingly more customized based on the practices of each different organization and the different data practices occurring. Kathy, you can go to the next slide. And then there's also terms of use, which you may have seen on different websites. And a terms of use, also referred to as a terms of service or terms and conditions, is intended to be a legally binding contract between the owner of the website or the organization and the website users. And basically what this does is establishes a click-through contract with that website user that protects the organization in case there's misuse of the website, any intellectual property, and it helps limit liability on behalf of the organization in this contract. And also, like a privacy policy, a terms of use needs to be customized to each organization depending on the different limitations you want to include, the type of organization that you are, the services you provide, the data collected, and things like that. Kathy, you can go to the next slide. And then beyond just including these types of contracts or policies on your website, you also want to protect the information that you're collecting through the website. So this includes having internal mechanisms in place, such as policies, cybersecurity safeguards, procedures, and data breach response plans. And failure to have these internal mechanisms in place can lead to costly data breaches and litigation, which many of which have become really high profile cases in the media and things like that. We're hearing more and more about large data breaches happening every single day. And another important part of this, beyond just your internal protection, is also making sure any vendors you use are also protecting any data that they have of yours as well. So this includes having a vendor due diligence policy and making sure that vendors you use have proper cybersecurity and data privacy practices through the contract that you're signing with them, making sure they have adequate insurances in place, and overall just checking to make sure that they're doing what they're supposed to be doing and what they're representing to. Next slide. And then lastly, what else do you need to know? It's also important to determine if you're subject to any specific laws around like website accessibility, about the donations you're collecting, or also just based on where you're practicing or the type of information you're collecting. So this includes the European Union General Data Protection Regulation if you're protecting information about individuals located in the EU. The Colorado privacy law, which goes into effect next year, does govern nonprofits in certain circumstances. And the California Online Privacy Protection Act requires certain documentation, such as a privacy policy, to be on a website. And these are just a few examples of the many laws that can govern your website practices, but also your general data collection practices overall in your organization. And I believe that is our last slide, Gabe.
Thank you. That was really comprehensive. Appreciate the time that Delaney and Shannon, you both took on an important set of issues for the not-for-profit community. I'm going to close out our presentation today with just a few brief highlights of items. First, something that isn't among my slides, but that at some level is late breaking. If you tuned in last week, you would have heard from Andy Bobrek, the previous moderator of Business in 22, who made a guest appearance as a presenter, who described the background around the potential railroad strike. And last evening, President Biden asked Congress to impose a labor contract to avert a rail strike. According to Politico, and others that are reporting, it's a politically potentially risky position for the president to take, given his oft-stated support for labor. But the president essentially focused on the fact that the shutdown could hurt millions of other working people and families, according to a direct quote of the president. So more to come here. We'll see if Congress acts, but just wanted to provide you quickly with that update. If you go to the next slide, please, Kathy. On the healthcare worker bonus program, for those of you who have been following this closely, that means that you're one of the employers that's likely brought into this going back to August. Just reminding all of you at the very highest of levels, November 30th is the filing deadline for vesting periods 1 and 2. So if you haven't dotted I's and crossed T's, now's the time. If you need our help for any of this activity, please reach out to the bond attorney that you're most comfortable working with. Next slide, please, Kathy. I also want to just remind you that this program continues to evolve, as I've talked about in previous presentations, and there will be a set of new individuals and new employer types brought in. We're watching that closely. We expect to learn more next month. This comes out of the mid-year budget update that the governor implemented shortly after the election. There'll be additional titles and employer types, as I mentioned. I also, though, want to caution all of you that if you think you're somehow connected to this, please wait. There's nothing that should happen before November 30th. We're waiting on more information from the New York State Department of Health. As soon as the department defines more squarely what this new group looks like, we'll get instructions out to all of you and in all likelihood walk you through it here on the program. Next slide, please. We can go to the next slide after that. And then again, we just want to remind you that if you are an employer who's working to finish your attestations or otherwise get the last bits of your activities around the program taken care of before the deadline tomorrow, please do reach out. We're here to help. And then finally, what I'm going to dispense with is our more formal summary of COVID material. The long story short is that in comparison with where things were 2 weeks ago, we're seeing generally a steady state around the country based on the data that we have, a 6% uptick in terms of reported cases in the last 2-week period. But with all the limitations we know about how these data are now captured. So we take it with that proverbial grain of salt. But what I think we're all experiencing is that we're still in the mix of a winter that will be yet another where COVID is among the factors, and but everything is as it was from a regulatory and policy standpoint. Nothing from the governor's office in New York or otherwise at the federal level that any of you should be paying immediate heed to, as we've brought before you in previous programs. And then one last note I'll mention, in the past I've talked with you about monkeypox and some of the concerns there. The World Health Organization actually just this week has indicated that it's seeking to shift the nomenclature for it to Mpox, eliminating monkey and making it just M. And over the course of the next year, we'll transition the name. And this is in response to questions around whether the existing terminology is stigmatizing. More to come there. We do know that the executive order relating to monkeypox, or Mpox as it were, was previously lifted by the governor. With that, I think for today's program, we will be available, of course, any of our speakers to follow up on questions you may pose to us offline. Please do let us know if you have them. You can find us via the contact information there. I will be back with you on December 13th. Amazingly, as I noted at the top of the program, we're just about at the end of 2022, a few more weeks. So I'll be with you on the 13th, and then again during the last week of the year is the plan. So until I see you on the 13th, wishing you all well. Enjoy this holiday season that we're more fully entering, and know that your bond team is here to provide you with support and to answer your questions. With that, have a good afternoon.